Well, hey there. Good afternoon. Bill O'Leary coming to you live this Thursday afternoon as part of our Thirsty Thursday series. I'm getting a little bit of a late start. It's now 4:20. I try to go live at 4 o'clock, but had a client meeting that ran long. So for those that may not know me, again, my name is Bill O'Leary. I'm an estate and elder law attorney from Legacy Planning Law Group. And I'm coming live as part of a weekly thing that we do called Thirsty Thursday, where I talk about a different topic that relates to sort of the kind of law that I do. Again, states and trusts and wills and elder law and so forth. So if you're thirsty for knowledge, you come to the right place. Now today's topic, in sort of honor of October being a special needs month, is it's how do you plan for a loved one with special needs? And since I really can't talk about as much as I want to talk about special needs in just one live presentation, I'm breaking it up into two parts. So this is part one, and next Thursday, next week, will be part two. So look, planning for a loved one with special needs can be a daunting task. The plan itself needs to be sort of flexible enough to really account for the unknown. There's going to be a lot of unknown things that happen in the future, but it's got to be sufficiently sort of tailored to meet the needs of your loved one now and in the foreseeable future. So, just some tips to keep in mind when you're planning for your loved one with special needs. First, to address sort of the foundational estate planning. Think of sort of the foundation to the house, the slab to the house. Let's get a solid foundation in place. So it's really planning for yourself first of all. Okay, that's where the foundation starts. So even though you, let's say as the parent or maybe sibling, may not be the one with special needs, it's important that you start with yourself and plan for yourself. So you're going to see why in just a moment. Be sure to have a will, a last will and testament, and if appropriate, to have a living trust in place. In fact, often that a family member that's doing their foundational estate planning that has a special needs loved one and they want to provide for them as part of their estate plan, a living trust is a much better way to do it than a will. Now, if you don't have proper estate planning documents in place, well, let's think that through. Your loved one that has special needs is going to stand to inherit some money, some assets, property, whatever it might be, from you, okay? And they would receive it outright, as an outright inheritance, an outright distribution. Well, doing so, receiving an outright inheritance may pose a significant problem for your loved one with special needs because they may no longer qualify for any sort of government benefits that they're receiving. Think SSI or Medicaid. So consider this. Have estate planning documents put together that provide that any share of your estate that's going to your loved one with special needs is not going to them outright, but instead is going into a special needs trust. Is going into a special needs trust. So a properly drafted special needs trust is going to let your loved one inherit what you want them to inherit, but it'll go to them in a way that's going to allow them to continue to get those government benefits. So it should also factor in maybe allowing other people other than you to be able to contribute money to this trust. Okay, that's one way to do it. So think parents, grandparents. Your special needs loved one, when the trust is sort of put in place, and it could be a trust you put in place today, or maybe it's a trust that sort of kicks in at your death. A couple of different ways to go about that. But the money or the assets that are in that trust, your special needs loved one is not going to have direct access to it. Is not going to have direct access to it. So someone else is going to be in control of that trust money, the principal and the income. There's going to be a trustee that you appoint that's going to have complete discretion over the use of that money in the trust for your loved one. Now, if you're the parent of a minor with special needs, then the will should also name a guardian and a successor guardian after that. In the event that you are deceased, and if you're married, both of you are passed. If you're deceased, or maybe you really can't effectively serve as a natural guardian. Let's say you become incapacitated. So, although a court proceeding, yes, in that situation will be necessary to formally appoint, the person as a guardian, nominating the person in your will now lets the court know ahead of time what your wishes are. So that's the first thing to really consider right out of the gate. Make sure that the estate planning for you is properly set up with that special needs trust. The second thing to really keep in mind is, how do you go about choosing a trustee for the special needs trust? The role of the trustee of a special needs trust is first and foremost, before anything else, is to administer the money in the trust for the benefit of your special needs loved one. Now, it's possible, and in fact, usually it's a good idea, to appoint a corporate or third-party trustee as well, and a family trustee. Maybe they could serve together. And the role of this corporate or institutional trustee is to invest and manage the money that's held in the trust. The role of the family trustee, that co-trustee, that's a family member, is to make the day-to-day decisions regarding distribution of the funds. So the family trustee really should be somebody intimately familiar with the needs that your special needs loved one has, and should be someone that's willing and able to make the decisions necessary to meet those needs. And oh, by the way, the corporate trustee, in addition to sort of handling and investing the funds, they should also have some familiarity with special needs trust and sort of know the rules and the ins and the outs to make sure that those rules are not going to be violated, so that the benefits will continue to flow. The other thing to consider is dealing with the inheritance despite the planning. Okay, so what happens? So your extended family, so not just you, but other family members that may want to provide something through their estate plan for your special needs loved one, they should be aware of the special needs trust that you've drafted and put together for the benefit of your loved one with special needs. And they should provide that any inheritance that they are going to be giving to your special needs loved one should, instead of going to your special needs loved one directly as an outright inheritance, should name the special needs trust that you're establishing, should name it as the beneficiary. Because if this is not done, then your disabled loved one may inherit the money or the property outright. So again, that's a real problem for a special needs individual that's receiving government benefits. They really cannot receive an inheritance outright because it's going to kick them off the rolls. Now, if they do receive an inheritance outright, there is a remedy for that situation. The special needs loved one can establish their own special needs trust. And by the way, if they're not capable of doing that, then you can have a parent, a grandparent, a legal guardian, or even a court can go ahead and establish a special needs trust for the benefit of the disabled individual. That's what we call a first party special needs trust. This trust is funded with the inheritance. The same type of trust will be established if, let's say, instead of the disabled individual receiving an inheritance, they got a pot of money because they got injured and there was some sort of personal injury lawsuit. Those are the two scenarios where a first party special needs trust would need to be set up. One, an inheritance, and two, a lawsuit settlement. Now, with this first party special needs trust, bear in mind there's a big catch. There's a big catch. The trust must include what's called a payback provision to Medicaid, where upon the beneficiary's death, your special needs loved one, upon their death, Medicaid is entitled to be paid back for money out of the trust, be paid back for any benefits that they paid out to your special needs loved one. But despite the fact that this sort of payback provision is required, it's better than not having this trust at all, which would mean kicking your loved one off the rolls while they're still living. And then the last thing I would sort of urge you to consider is preparing a letter of intent. A letter of intent. So again, this is not a legally binding document, but it's really important and should be completed when your estate planning documents are prepared. And in fact, not only just prepared once and done and put in a drawer, but it should be updated regularly. The letter of intent really provides guidelines for your loved one's care plan. Okay, so it lays out sort of the medical information, emergency contact information, maybe some academic or social information, and other sort of important information that's necessary to manage your special need loved ones' daily care needs. Once complete, a copy of this document should be given to the trustee of the Special Needs Trust, and oh, by the way, if your loved one is a minor, also given to the guardian that you nominate. So, again, it's just I think that letter of intent a lot of times is overlooked, but it's very powerful. Letter of intent. So again, as I said at the beginning, this is sort of part one of a two-part series. Short talks about special needs planning. Next week I'm going to have part two, and I'm going to be talking about topics like how do you handle life insurance and retirement accounts? What about guardianships and advanced health care directives? What about eligibility for government benefits? And what about you being a good advocate for your special needs loved one? So that's what I'm going to talk about next week. So, hey, if you'd like to know more about special needs planning, how you can plan for a loved one with special needs, and maybe if you'd like to know how we can help, I encourage you, go ahead and reach out to us and schedule a 15-minute free discovery phone call, okay? It's a chance for us to start a conversation, okay? We can find out what's really concerning you. You can book it on the Book Now, through the Book Now button on the Facebook page, or just Google us, LegacyPlanningLawGroup.com. So, hey, if you've enjoyed this video, I'd ask you to like it, better yet, share it with your friends. If you happen to know anybody that maybe has a special needs child, they're starving for information about special needs planning. So that'd be great if you could share it with them. So again, I hope you've enjoyed this talk. Again, it's part one of a two-part series, how to plan for a loved one with special needs. I'll go live again next Thursday at about this time, so if you're thirsty for knowledge, you've come to the right place. So on behalf of everybody here on this Thursday, October 14, boy, we're halfway through October already. On behalf of everybody at Team Legacy, go make it a great day and actually make it a better world.